All right. Where are we, folks, on this?
We have
I did receive the email this morning, or the message this morning. So.
yes.
Before we dive into the words of Judge Simpson, let's set the stage. This case is tangled in delays, conflicting recollections, and disputed evidence. At the heart of it, surveillance videos that appeared late, far too late, and a dispute over whether the defendant's earlier agreement to comply with conditions should have closed the matter. Imagine walking into court thinking your case was essentially done, only to have the rug pulled out the very next day. That's the drama unfolding here. We'll see prosecutors, defense, and the judge wrestle over missing videos, botched communications, and whether promises made were promises kept. Stay sharp, because this case will test not only the patience of the court, but also your sense of fairness. Was the system sloppy, or is someone playing games? You'll be the judge as we move through it.
I did let him know about the videos and that I just received them after 11 o'clock last night, opened them early this morning. We do have all of our witnesses today. It's my understanding that Mr. Hall would be objecting to admission of the videos. As a result of that, I would be requesting an adjournment so that he has adequate time to review them with his client, and we would be able to use them at the next available bench trial date. I do want to note for the record that I did previously request all media associated with this case and was told that we had everything. So at this point, I'm not exactly sure where the gap was between that request and us receiving these surveillance videos. But at this point, I did not receive them until after 11 p.m. last night.
Your Honor, I received them at 8:30 this morning. Once Sister Counsel told me that they were in my inbox. And according to the police report, they were downloaded on January 24th of 2023. So they
Downloaded to.
police report just says they were downloaded. I'm not sure if it was to evidence.com or where it was downloaded to. That would be my assumption. And this case has been going on for nearly 15 months. So I would also object to the adjournment.
The confusion here is striking. Evidence in criminal cases has to be handled with precision. Surveillance videos, especially those from Ring cameras, can be make or break, placing the defendant at the scene or undermining their defense entirely. Yet, what we're seeing is a muddle of half answers. Downloaded here, uploaded there, maybe not at all. This isn't a small clerical slip. It's potentially a violation of discovery rules. When the defense doesn't get evidence in time, it compromises their ability to prepare. Judge Simpson is clearly pressing to understand why the system failed. Was it negligence, or worse, selective sharing?
Your Honor, I checked evidence.com yesterday. I had 4 videos, actually, or 2 videos, I believe. I did not have the surveillance video yet.
And these, the description that the court got was that they're Ring videos of, what are these videos? Yes. Ma'am, you can have a seat. No, you can sit right there. Okay, it's okay. They have to stand, but.
They're surveillance videos of the victim's home.
From where, though? I mean, I guess I'm trying to figure out.
It's surveillance videos that are Ring videos, which the Ring systems are operated by the victim, equipped to his home, and include video of the alleged conduct by the defendant.
And those are the only videos in this case.
There's body cam, and that was already submitted and uploaded into evidence.com, which was the video that I had available to me prior to 11 p.m. yesterday.
That's what I'm trying to figure out. What I'm trying to figure out is, Mr. Hall, when you reference something in the police report that says the video was downloaded, are we talking that video or are we talking other video?
It says David emailed me his surveillance videos of his front and backyard.
Got it.
I downloaded them on my computer.
Okay.
My understanding, Your Honor, is that they were downloaded to the internal Pittsfield public safety server, but not uploaded into evidence.com. I don't know what the gap was when I asked for all media associated with this case, why they were not uploaded.
Did we ask why that happened, or?
I have not had an opportunity to hear back from them as to why that did not happen.
And you viewed the video?
Briefly. I viewed the original video, which is body cam of the video on a computer.
Say that again.
So
The
during
other videos you've seen and viewed those.
body cam video, yes.
Right. This video is the one that you're saying you just saw this briefly.
Yes. The ring videos, they're much clearer and
They're clear.
yes. Those HD cameras now.
This is the first big dramatic reveal. The videos are not just late, they're in high definition. In court, clarity is everything. Blurry footage leaves wiggle room for doubt. HD surveillance that can capture every detail. Facial expressions, movements, interactions. The defense argues timing. They didn't get these until last night, meaning no chance to cross-check, consult experts, or build counter-arguments. The prosecution's resistance to delay, meanwhile, leans on the length of time the case has already dragged on. Here lies the tension, fairness versus efficiency. Do we rush forward and risk injustice, or pause and risk frustration? Judge Simpson knows the stakes. The integrity of the trial could hinge on this single decision.
Yes. I have like 8 of them. And your grounds for objecting to the adjournment is solely because of length of time, as opposed to.
Well, that and well, yes, and this case there was a plea offered and entered into at some point, and then that during the pre-plea version, that plea was pulled, and it continued on the trial, and a resolution was never reached.
I don't think that's an accurate statement of the record at all. Plus, we don't do pre-plea diversion in this court.
So I don't know what that is.
Maybe it was just a regular diversion.
There was no diversion in this whatsoever.
Yeah, I can help. This was a case where Patricia Reiser had offered, if she was to complete a mental health assessment and recommended recommendations of a therapist, along with do not violate the state law for 3 months and no contact with the brother for 3 months, that the case would be dismissed.
Now we hit the second layer of conflict, plea deals and diversions. The defense insists their client completed all conditions: mental health assessment, law-abiding behavior, no contact with the alleged victim. Normally, that means dismissal. But here, prosecutors argue there was no binding agreement, no victim consultation, no official record. This is huge because plea deals are essentially contracts. If the defendant delivers on their end, pulling back an offer after the fact looks like bad faith. What we see is a messy breakdown in communication between prosecutors past and present. One attorney allegedly promised dismissal, another denied any such deal existed. That inconsistency doesn't just waste time, it risks eroding trust in the system itself.
My client did, or Ms. Julian did do everything required under that. However, after it was completed, the plea was essentially pulled. She was no longer able to do that.
Your Honor, we have been over this multiple times. There was no note of that offer whatsoever made.
Well, I understand that, but
It also wasn't discussed with the victim whatsoever.
well, that may be somebody else's issue. All right. So
And after,
was that offer given?
Your Honor, I have not been able to confirm either way, but what I do know is we had went on to additional negotiations afterward where another offer was formally recommended, offered and discussed, and we had agreed on it.
No.
Your Honor,
If the offer, so,
Patricia Reiser, in the case, me and Morgan Barroso were on a Teams chat. She did confirm that the offer was there, and that was the offer. On I think it was the second final settlement date.
And Ms. Julian also did the psych evaluation. She completed it and a report was produced.
And I do have that report available. I can print it off now if you'd like.
That was not my understanding of the communication with Ms. Reiser.
okay, so hold on a second, folks. If I guess, was there, Ms. Kuhn, something to your understanding or anybody's understanding that if that offer was made, that as to a reason why it was pulled?
Because the victim did not agree to that.
And
Was
then-
the reasoning that was given.
And there was a change in the APA.
Yeah, and there
There was a what?
Change from Patricia Reiser to Morgan Barroso.
Yeah, it wasn't that the victim didn't agree to it. The victim was never consulted about any resolution whatsoever, which he is entitled to because he claimed his victim rights under the Crime Victim Rights Act.
But that's not my client's responsibility to make.
Well, okay, I get that. I hear all of that, but I mean, I guess the problem that I have outside of the alleged victim, their approval or their whatever, at some point, Ms. Julian is told to do something. She's told to do something that is sort of the ultimate resolution. That being, the case would be dismissed if you do these things. It's not, if you do these things, we'll give you a misdemeanor or something along those lines, that you still have to plead to something. For her, it goes away. And so then so from my understanding, and folks can correct me if I'm wrong, she does those things.
Correct.
At that point, then, I guess, the victim is contacted, the alleged victim is contacted, doesn't agree. And then and so then that offer doesn't happen.
Judge Simpson is visibly grappling with fairness. He lays it out. The defendant was told, do this, and the case goes away. She did it. Then suddenly the rug is pulled. This isn't just a legal wrinkle, it's a human problem. The defendant followed the rules only to face shifting goalposts. The prosecution's stance. Without written documentation, the deal was never real. But oral agreements, when relied upon, carry weight. Courts don't look kindly on bait and switch tactics. Here's the kicker. The victim wasn't even looped in at the right time. Prosecutors now say their rights weren't respected. So what we've got is a tug of war between procedure and promises. Simpson's frustration shows. He knows both sides have failed in some way. And here's where I want to hear from you. If justice depends on trust, what happens when neither side seems fully credible? Can the court salvage integrity here?
There's something wholly wrong with that whole scenario.
Your Honor, my understanding is not that the victim was contacted, it was that there was no documentation of that offer whatsoever. And the victim
Well,
was.
but Ms. Barroso, that's not my issue. My issue is that there was an agreement to do something. Defendant does it. Now, if on that side, what you needed to do wasn't done, that's a whole other thing. But I don't. Court stands in recess.
All rise.
Yeah.
You guys got through that. You got through what the communication I have.
Correct.
All right.
That is not correct,
What's not correct?
that she did not complete it,
That what?
that she did not complete it. I went back through my emails and on February 8th, prior to the February 9th final settlement conference, I forwarded along what Ms. Coombs sent me about what Ms. Julian had done to Vapa Riser and asked her if this passed muster for an offer, if there was one extended, and I never received a response. There was nothing from Ms. Riser. There was nothing documented about an offer. There was nothing documented about a dismissal in our file. Without anything documented in writing about an offer or a dismissal, we appeared the next day and we had the conversation in your chambers about how I didn't have any information about it, and without any confirmation, I did not feel it was appropriate to dismiss the case, so it was set for bench trial, especially with the victim being present on that day.
This is a masterclass in legal mismanagement. Emails, team chats, mental health reports, everything points to an agreement, yet somehow nothing is officially documented. That gap creates chaos. Defense lawyers argue their clients' expectations were set. Prosecutors argue nothing binding existed, and Judge Simpson is left to referee a game with shifting rules. Notice his pointed remark: if an agreement had been placed on the record, everyone would be stuck with it. That's the safeguard courts rely on. Clear records. Without them, deals dissolve into hearsay and finger pointing. For viewers, this moment underscores why documentation matters. Think of it like a contract without signatures. You can claim a handshake deal, but try enforcing it later. Doesn't hold up. And the consequence here is severe, a defendant potentially facing trial after fulfilling obligations that were supposed to end the case. Should verbal promises ever be enough in a courtroom?
Okay. So, okay.
Your Honor, I have an email here from Ms. Coombs to Ms. Julian on December 8th, and it specifically outlines the plea offer, no contact with the victim, no violation of state law, and get a mental health evaluation. And then I also have a mental health evaluation that was done on the 28th, and then a follow-up from the mental health coordinator on February 1st. And
I don't think the people are, I mean, from what I'm hearing, she's not disputing.
That was conveyed to Ms. Riser. I just did not receive anything saying that that was an offer from Ms. Riser, that was confirmed. I understand that Ms. Coombs is saying that there was a Teams message on the day of final settlement. That Teams message was not explicit that that was the offer that was extended. I did not understand it that way.
Your Honor, if I can, I laid out the offer inside the Teams message and I said, can you confirm this is the offer? To which Ms. Riser replied, yes, that is the offer. To which Ms. Barroso had replied, the victim did not consent to that, and that was the issue.
And then it wasn't until February 9th, which is the day after the 3-month period had run, and Ms. Julian was coming to court thinking that her case would be dismissed that day, when the rug was pulled out from under her and the offer was supposedly withdrawn.
On what day?
February 9th.
I'm not disputing anything with that. I'm doing the best with the information that I have that was not confirmed to me.
I mean, the agreement was that she completed the
Folks,
3
folks,
things.
everybody stop. Everybody just stop. I get what the agreement is. I have now this communication from Ms. Riser that's her recollection of the agreement. I also have at least confirmation in my understanding that Ms. Julian did what she was supposed to do under the agreement of the parties, or that was between the parties at some point. The issue here, however, is, I guess, that the victim did not or wasn't consulted about it. But that's not what I am taking, and I don't know if we need to have Ms. Riser here. This is certainly her recollection, but specifically in the communication she sent, Ms. Riser was of the belief that the victim has said that they were okay with that resolution and that ultimately out of all of this, they wanted to be left alone.
This is where the emotional weight really surfaces. The alleged victim's stance becomes clear. He's exhausted, he's tired of court, and he just wants to be left alone. That single statement reframes the entire case. For months, legal teams have sparred over documents, timelines, and technicalities. But in the end, the human being at the center just wants peace. This raises an important question: should the court prioritize a victim's exhaustion over the strict legal process? On one hand, victim rights are central to justice. On the other, cases can't simply vanish because someone feels worn down, otherwise precedent collapses. Judge Simpson's frustration here is visible. He's torn between respecting the victim's wishes and maintaining judicial order.
Yes, and
But now I'm hearing today that the victim is not okay with that resolution.
My understanding is that resolution was not even raised with the victim as a potential resolution.
Your Honor, the victim was at the final settlement conference. From my recollection, there was a conversation on what his position was at that time of mental health and the no contact, and it was a creative solution. The plea was.
But you were, I understand what you're saying, Ms. Coons, but you weren't a part of that communication. You believe that there was a communication that may have taken place either with the victim's advocate or with Ms. Rice, with the alleged victim in this case. Is that right? I mean, you're giving me your impressions of what
Yes.
you thought a conversation that happened.
Correct, but I was not a part of that.
And on this day, I'm presuming the victim is here.
Yes, he is.
Now we see the live tension of courtroom drama. The victim, present in the room, rejects the earlier resolution. Think about that. The defense walked in believing the case was effectively closed, but suddenly, in real time, the victim says no. That moment is crushing for the defendant, who thought compliance equaled freedom. This highlights a larger flaw in the system. Deals made without full victim consent are shaky at best. Prosecutors should never have floated dismissal without ensuring the victim was on board. Instead, they've set the stage for disappointment, conflict, and wasted court resources. Judge Simpson has to untangle this knot in front of everyone, balancing fairness against legal missteps.
He is not okay with the resolution. That was,
After all of this, he says whether we have the trial today and go forward with it or dismiss it, he is going to just be seeking a PPO. He says he's just tired and just wants to be left alone. So if we're not proceeding today, that's fine. If we are proceeding today, that's fine. He's been run through the ringer. He just wants to be left alone and will be seeking a PPO, whether it is stipulated to or not. That's all that he is caring about at this point.
And based on that and everything else, Your Honor, I would move to dismiss.
well, I get to deny your motion. Okay, I could dismiss it. Because the agreement, there's an acknowledgement of the agreement, but, and I had my staff check too, because if the agreement had been placed on the record, then everybody would be stuck with it. It wouldn't matter. But so my understanding now, I guess, based upon what you said, Ms. Barroso, is that the victim in the case is indicating exactly what Ms. Reiser has said. They said that they just want to be left alone.
That is the first time he has said that today. In all of my conversations with him and all of my advocates' conversations with him, since I was speaking over the case, that is the first time I have heard that out of him. But at this point, he's now appeared 3 times and he's done.
Well, maybe, maybe not. What I'm inclined to do is, your client was trying, I don't know if she was trying to say something to you. She may want to mute the microphone if she's saying something.
They haven't had contact in over a year and a half, so it's not like, she's stalking him or trying to get a hold of him. She doesn't want contact with him either.
Can I talk? No?
Well, here's what I'm inclined to do, folks. What I'm inclined to do, and I be very careful how I say this, but I'm inclined to disallow the evidence that was just provided and exclude it from any trial and just proceed to trial on the matter. The parties can't come to some resolution.
This is the pivotal ruling. Judge Simpson, with years of experience, makes the call to exclude the late delivered videos. Why? Because admitting them would unfairly handicap the defense. This is a classic demonstration of judicial discretion, protecting the integrity of trial over the convenience of the prosecution. But notice the nuance. Simpson goes out of his way to defend the police department's reputation, saying this was likely error, not malice. That's deliberate. He shields the credibility of long-standing officers while still holding the process accountable.
In doing that, I want to make it very clear that I'm doing that because defense counsel just got that information, but in no way am I making that ruling attributing that there was any indication that the Pittsfield Department of Public Safety or Officer Richler was attempting to try to not provide that information. And I say that because this officer's been before me for a couple decades, maybe. I don't know. 20. So right after I started. So in a quarter century. Anyway, and has always been forthright, would not engage in anything to withhold anything. I would see it as being an error, but that error in terms of it happening and then ultimately getting corrected has inured to what may be a not a benefit to the defendant, and certainly may cause, so I haven't seen the tape, so I don't know, but may cause some issue. So what we'll do is I won't allow it. We'll proceed to trial. And you guys have 15 minutes to get yourselves ready, and court's in possession. And there's been a in-chambers conference. I'm going to adjourn the trial out to, what date is that?
May 1st.
Jury trial to May 1st, 2024 at 9 a.m. That's a special time.
The ruling sets the stage for yet another delay. A jury trial is now pushed months ahead. For the defendant, this means more uncertainty. For the victim, more exhaustion. And for the court, more resources burned on a case that should have been resolved cleanly months earlier. What we see here is the cumulative effect of poor communication, half-kept promises, and sloppy evidence handling. Justice delayed isn't just justice denied, it's justice twisted. Each postponement chips away at confidence in the process. This is why Simpson appears both authoritative and weary. He knows this trial has lost its footing. The audience needs to recognize how small cracks, an email here, a missing upload there, can snowball into years of chaos.
All right.
Just to put it on the record.
Yes.
If I get the order signed before then, the hearing will be.
The trial will be canceled.
And the case will be dismissed.
Dismissed. Is that correct, Mr. Roll?
That is correct, Rick.
All right, very good. We have that all on the record. Okay, thank you, folks.
Thank you for your time.
And that brings us to the conclusion. Judge Simpson has spoken, and this case now pivots toward a jury trial scheduled for May 1st, 2024. Along the way, we've seen delayed evidence, disputed plea deals, victim fatigue, and a defendant caught in limbo. The bigger picture, This case exposes the fragility of courtroom procedures when communication breaks down. Deals only matter if they're documented. Evidence only counts if it's shared properly. And victims' voices, while vital, must be integrated into the process early, not at the 11th hour. Simpson's ruling to exclude late surveillance footage highlights a fundamental principle: fairness trumps shortcuts. Whether you side with the defense, the prosecution, or the victim, one truth is clear: justice isn't just about outcomes, it's about process. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.